quorum. Senator Utke was the very first one here, and he was not on Senate time. He was actually, way ahead of time. So that was supposed to be funny, but I guess I'm not funny anymore. So you're right, EMQ. I should. Today, members, we have 4 bills on our agenda, beginning with the legislation that Schumacher and Noor and the other body worked on and sent it over. I went ahead and took that bill. And so then we also have Senator Rasmusson's, Senator Maye Quade's, and then Senator Wiklund. You guys, is that order okay for everybody, or does somebody else want to go first? You're good? All right, I got thumbs up. So in front of you, members, is Senate File 3755. And there's an A1 amendment in front of you. I would like to move the A1 amendment. It is my author's amendment. And that's the amendment that Schumacher and Noor were supposed to add Senator Rasmusson to their bill, and they didn't. So we're going to be kind enough to put it on and send it back. When we do, it'll be a good conversation. So I move the A1 amendment. All those in favor say aye. Aye. Opposed, same sign. Thank you. Members, this bill, it's a simple bill. It addresses 2 issues that are integral work. Oh, Senator Utke. Yeah.
Thank you, Mr. Chair, and I hate to interrupt you this quick, but these guys are handing out the amendment.
The A1, yeah.
All of the amendments were posted online already, so they could go ahead and get them all handed out now while you're doing your presentation, and then we'll be ready for you to go forward. Thank
you. To that point, Pages, if you could go do as Senator Utke said, hand all the amendments out. Thank you, Senator Utke. The bill that is in front of us, the Senate File 3755, addresses 2 issues that are integral to the work of this committee: program integrity and separation of powers. As you know, members, last year in our special session, as featured in CARE 11, A.J. Legault put in there that we just did we were able to fix housing stabilization. Senator Abler, remember that conference committee where we did that? And it was about program integrity, and we need to codify the repeal of the Housing Stabilization Services Program. As members know, Governor Walz took the step of terminating the program this summer due to fraudulent activity. We are now taking the step to repeal that statute, which authorizes housing stabilization services, right? And that brings me to the second part of the bill, which is the separation of powers. All of us in this committee take program integrity and credible allegations of fraud seriously, and it is clear that housing stabilization funding was being misused. While I appreciate the governor's willingness to act quickly and decisively to stop the fraud, it's only the legislature that can repeal a program established in statute. Senator Rasmusson, our earlier conversation. This is a fundamental prerogative of the powers held by the legislative branch, which balanced against the powers of the executive branch. There's 2 different bodies of legislative authority. The language in that author's amendment stipulates that the executive branch may not terminate a statutory program until authorized to do so by the legislative branch. The language also strengthens transparency by requiring the agency to post the text of all public comments received when preparing amendments to the state's waiver plan. I've also this committee received some technical assistance from the Department of Human Services, and there's an A2 amendment. Mr. Grom, if you're in the place, could you come on down? And then Senator Abler, I thought you had an A3, but instead it's an A4, so that you must have combined the 3 to the 4. What's the deal? Oh, there we go. Steely Dan. Ms. Grom, you looked at the work that the other body had done and sent over to this wonderful upper chamber, and you said there needs some technical changes. Could you tell us about your A2 amendment, and then somebody on this committee, Senator Utke, do you want to move the A2 amendment, and then we'll have her present it? Is that good?
Yes, I'll move the A2.
Senator Utke moves the A2. Ms. Grom to that amendment.
Thank you, Mr. Chair and Committee. For the record, Christy Graham with the Department of Human Services. Glad to be back in the upper chamber. So this amendment has a few technical clarifications and then one item that's more of a policy change that I'll describe to the committee. So beginning on line 1.3, the changes in section 2 are just technical, removing the reference to housing stabilization services in the background studies language, cleaning that up. And then beginning on line 1.32, there is another technical correction that we're making. Last session, there were a lot of program integrity reforms made for both recuperative care and housing stabilization. And could have been the department's fault or probably not council's fault, but we made an error where we referred to housing stabilization services in the recuperative care statute. So we are correcting that mistake that we made on lines 2.1 to 2.2. And then on line 2.4, you'll note deleting section 7, which is, I believe in the bill, the initial repealer that you described, Mr. Chair. And that is reinserted in section 9 of the amendment. And it's the exact same as the repealer in your bill, Mr. Chair, save for paragraph C repeals a portion of session law that references housing stabilization services and tribal encounter rates. So just cleaning statute up and making sure that that repealer is comprehensive. And then the insertion of section 8 is something that the department heard from community and heard from legislators about last late summer and fall as it relates to housing stabilization and the termination of that service. So this is a requirement that DHS work with community, we consult with the legislature, and we look to redesign a potential Medicaid housing service, one that has stronger program integrity controls. We're interested in working specifically with tribal nations to determine if we would maybe develop a benefit specifically for tribal nations. Look at how can we make sure that we're getting outcomes for a new Medicaid service of this nature, and make sure that what the legislature and taxpayers are paying for is good for people. And then we would report back to the legislature in September of 2027, noting what our recommendations are for a potential redesign of housing stabilization services or a similar benefit to be able to draw down that federal match. So, Mr. Chair, I believe that's the amendment, but happy to answer any questions.
Go to Senator Rasmusson and then Senator Abler.
Thank you, Mr. Chair, and thank you, Ms. Grom. One question I have, and I'm just trying to follow the different amendments we have here, but in the bill in front of us, I'm looking at the language, the commissioner must not take the following actions without prior enactment of legislative authorization. And then it talks about terminating medical assistance program waiver or benefit, or to request federal assistance in terminating a medical assistance program waiver or benefit. And if I back up to last year, we had the Housing Stabilization Services Program was found to have a an unacceptable level of fraud within that program. And you effectively had the administration determine that there was so much fraud in this program that the best course of action was to shut it down, and requesting that CMS authorize that program to be shut down. And so, Mr. Chair, my question for Ms. Grom is if there is this kind of language in law, would that have prevented the department from shutting down the program and potentially allowed for more dollars to go to fraudsters?
Ms. Grom.
Mr. Chair, Senator Rasmusson, I think that's the amendment, and I don't know that I have it in front of me. Tell me if I'm wrong, and you can point to the page in line, but potentially, yes, that would have limited our ability to do that. I'm trying to recollect from memory what that amendment looked like in the other body, and if there was any requirement about consulting with the legislature, but perhaps others can share if that's in the amendment. I would say we want to work with bill authors on this. We understand the legislature's intent here, and we're happy to continue to work with you all. I think the part of that amendment where we want to do some work in particular is around making substantial change, I think is, or significant change. I can't remember the exact verbiage. We just want to make sure that we are able to get things passed or approved by CMS when that's the legislative intent. So there could be some unintended consequences for that particular provision.
Thank you. And actually, Ms. Crum, the pages should be bringing you the amendments to that. That was kind of the same question that's why we did in our conference committee. It was to, right, Aaron Maye Quade, do you remember that? This is why we actually had the extra time to be able to fix that. And so would that have been, same question is, our fixes, would that have made a difference, or why did we go ahead and do that? So I'm going to jump ahead because Aaron Maye Quade, to your point, no, you were to that point, Aaron Maye Quade. Unless you, to that point? No? Yes.
Yes, Mr. Chair. I mean, I think, one, we did make a lot of changes in housing stabilization in June of this past year.
Yep.
And then in August, the executive branch said that we're going to end a program that the legislature put into statute. And I think we can, once we get into specifics, it becomes really easy to justify that creep of the executive branch into the legislative branch's roles and duties. But ultimately, if we don't make it very clear that the legislature is the only one that can end legislative creative programs, regardless of what's happening in them, then we will be giving up our job. We will be giving up the function of our body, and I'm not willing to do that. And so that's why we put program integrity measures into place. We didn't even have time to see if those are going to be effective. And so I think this is a good amendment because I'm ready to stake a claim on legislative function and hold on to our role.
Thank you. To that point, Senator Rasmusson.
Thank you, Mr. Chair. And a follow-up question for Ms. Grom. I mean, Ms. Grom, could you provide some context as to why the administration made the determination to end the Housing Stabilization Services Program? Because I think my concern was, while there might have been some program integrity enhancements that were passed last year during the special session or the regular session, from my point of view, it obviously wasn't enough, right? And we still had major program integrity issues with this program that led the administration to determine it'd be best to shut it down. And so I'm just trying to understand that thought process here. And would this type of language prevent you in the future from being able to address a program that has a high level of fraud in it?
Ms. Crum, that's actually good. Ms. Crum.
Mr. Chair, Senator Rasmusson, you are correct. It was a very painful decision to terminate that benefit for many at the department. I think you've probably heard the commissioner say we come to these jobs because we want to do more services, we want to support people using our Medicaid program, and to support people so that they can maintain and find their housing. That's an important part of healthcare. But what we had found was the level of fraud was unprecedented in the program, or I should say credible allegations of fraud was unprecedented. So we did take an unprecedented step to reach out to CMS to determine what the path forward might be after doing some data analytics in the program and trying to understand what exactly was happening there, but also after hearing from our law enforcement partners that at the level of credible allegations that we were detecting, that they would struggle to even have the resources to prosecute and hold the fraudsters accountable. So it was at that time that we had to make the very painful decision to move forward with our discussion with CMS.
Senator Rasmussen.
Thank you.
I just want to make a point. I'm sorry. Early on, I'm just Senator Maye Quade. I said EMQ, and it's like, that's not, I'm acting like you're back in the other body, so I apologize for not calling you Senator. Senator Rasmussen.
Thank you, Mr. Chair. Thank you, Ms. Grom. That's helpful. I mean, and one of the things that, as I've been researching and looking more into housing stabilization services, would it be fair to say, I mean, it's my understanding that Minnesota's program was quite unique compared to other state Medicaid programs, and that really Medicaid isn't designed to be a housing benefit. I mean, can you help me place context? Are there a lot of other states that effectively try to use Medicaid for a housing program? Are there any restrictions on our ability to do that? I'm just trying to place this within the context of what other states might be doing.
Ms. Crum.
Mr. Chair, Senator Rasmusson, we aren't super unique. I mean, the Minnesota's Housing Stabilization Services Medicaid benefit was unique in the fact that I believe we were the first state to request a 1915I waiver, which is a home and community-based services waiver, a newer kind of waiver to deliver this benefit. So we were unique in that aspect. We may have been the first, and there might have been one more state. However, my understanding is that there are a handful of other states that provided similar services under different authorities. I don't have the number, so I don't want to speak definitively, but this is a new area of Medicaid funding, I would say, to your point. Really acknowledging that health-related social needs are important for a person's overall health and their health outcomes. So it's certainly something that can occur in the context of Medicaid, but it is newer.
Thank you. To that point, Senator Abler.
Well, thank you. And are we on the A1 or the A2 amendment right now?
We're looking at the A2, Jim. Or Senator
We're
Abler.
doing the A2, talking about the A1. Got it.
Yeah, A2 talking about the A1.
I was just confused. So for the viewers at home, A2 with A1's coming. Anyway, so thank you for the hearing and the bill. Did I sign it? I'm not sure. I think I did not sign it. And we're going to do what we're going to do, but I'm disappointed. I think the department had ample tools at their disposal to go after the people that were the worst. We call them Lucky Leo, the person from Blaine that had 22, that's the name of their company. I don't remember that fellow's name, but he had 22 places at one address and drove a Range Rover. And just to the people reviewing all this, I think if you talk to your operators, if they're driving a 2003 Volvo, probably they're not a fraudster. If they're driving a 2026 Range Rover, I think we want to worry because there's no money in this business. And I was, and I'm not going to go on very long, but I was just really disappointed that, yeah. And so there were some people, I forget the name of the company, they hired 18 staff to handle 400 people. They were above legit. They were like a model for how to care about people and do this service in the most highly ethical way. And November 1st, they were done, and they didn't do anything wrong. And we have a messenger sitting here talking to us today who is not a decision maker, and I don't know who really decided, but Senator Hoffman, you and I, and Senator Maye Quade, and others put in place some really good guardrails. And as I read the repealer, like there's all our good stuff that's going to be repealed now, and the program wasn't well designed. But I'm just disappointed for the people who were being served, who found themselves homeless on the way into the winter, which was actually quite cold and snowy right at that time of the year. And it's ironic to me that with the tools that the department has to do credible allegations of fraud, which I think they may overuse sometimes, or they use it, but there's no, I'm working on due process in that. And I think some people should absolutely be cut off, and they should have cut off Lucky Leo, and these other ones just like said, you're done, and then leave the program open for the remaining 2/3 or so that were doing a good job. So that's why I was reticent to repeal it. And so, I don't know if I'm to the amendment or whatever, but at some point, can we maybe get Ms. Bailey down here and ask her in the forecast, what happened to the money? And is that a good question?
No, it's a great follow-up because that leads to $300 million of money that was moved into the general fund because of that stuff like this. And there might even be more than that. It's a great question to ask. The smartest person we know when it comes to finances in the state of Minnesota and the Department of Human Services is in front of you right now.
So thanks,
Senator
Mr. Chair.
Abler.
So at least do the math, Bailey. And so can you just, maybe I'll ask you a few questions, and they're not that hard, but like how much money was moved into the general fund from this cancellation in the forecast? And so if we set up a new program, is that going to have to be all new money? That's my start question.
Ms. Bailey.
Chair Hoffman, Senator Abler, for the record, Elise Bailey, Budget Director at the Department of Human Services. I have the numbers by year, so you may need to add them up.
Okay.
But when we did the November 2025 forecast, we knew at that time that HSS was ending the month prior. And therefore, we eliminated the state-funded amounts from the forecast. There was a few offsets, assuming that folks would receive other services in our forecast programs, but the net impact was 21.5 million savings in fiscal year '26, 41.8 in fiscal year '27, 48.1 in fiscal year '28, and 49.9 in fiscal year '29. So give or take, I don't know, 160 million or so.
Yeah.
And then, to answer your second question, once we come back with a recommended new program, yes, the legislature would need to fund that program.
Yep, and then I think that's what the other body has intention on that. So this conversation is far from over, Senator Abler.
Well, thank you, I appreciate that. And Senator Hoffman, I believe the number of the surplus in '29 is 377 million?
Yeah.
Something like that. And so this program alone is worth 40% of that.
I know.
From this committee. So again, this committee is donating to the good of the state to the detriment of the clients. So
Do you remember in 2023, Senator Abler, I believe it was $1.825 billion that this committee
I think Senator
donated
Maye
to
Quade
that. I
is
think Senator
running
Maye
counter
Quade
to
was,
So thank you, Mr. Chair, we worked in a very collaborative way in this working group with the department, coming up with these various arrays of programming, of improvements. And I guess I'll make it a comment. So I don't know how they found time to authorize 1,800 companies when the whole 245D, et cetera, licensure thing is backed up like by a year or something. And I mean, I just don't understand. It just seems irrational to me. And Mr. Chair, I'll be done after this to this amendment. But so one of the fixes that we're repealing, I think it's still in the recuperative care part, and maybe it's elsewhere, where they have to demonstrate that they can actually provide the service they say they want to do.
correct.
And that was not present before in the design, which I hope that's in every design from this point forward. So thank you, Mr. Chair.
Thank you, Senator Abler. That Senator Gruenhagen to the bill.
Oh, do you want to stay?
I want to flee, no.
She's running out the door. Did you ever see Spaceballs, the movie, when the guy said, "And here they come, and out the door they went"? So, you know, Glenn, what do you think?
Okay.
No, Senator
Yeah.
Gruenhagen, I gotta.
Yeah, thank you, Mr. Chairman. Yeah, one of the things that has been reported, at least, is that laws were just ignored, okay? So we can pass all the laws we want, and if they're ignored by the people in charge, I mean, what's the consequence? In other words, I listened to a DHS employee who just said that, a lot of her fellow employees reported fraud and said, hey, there's a problem here, and they were threatened and they were persecuted for doing it and threatened with their jobs and even their families, that was on national television. So, when I look at this, it's a lot of fine-sounding language like evidence-based practices to prevent and reduce homelessness. I mean, there's fine-sounding words, but what's the consequence for promoting fraud? I mean, are the feds going to be satisfied with what we're passing here in terms of accountability? Or is this just, well, we're doing this and they're going to say, well, that's not enough? I don't know. To me, they want on-site verification and a better verification process with consequences. And to me, when I'm looking at these, and again, I just first time looking, there's not a lot of consequences in here. And if we're just going to ignore the laws we pass anyway, which is what has been reported, I mean, are we just wasting our time? Or are we actually going to show some accountability to the feds? They're holding about $500 million a quarter. I don't know about you, but I'd like to make sure that money, we get it here at the state, and that it gets to the people who really need it, rather than to the fraudsters. And I don't know if what we're doing is actually going to accomplish that. I'm open to trying to be convinced about it, but appreciate if somebody would respond to that.
Senator Abler to that
Thank you,
point.
Mr. Chair. Actually, if you read in the repealed language in there, I think there must have been 10 things we did, including limiting, if they could have put this in place, there wouldn't have been any news. And that's my frustration, that we took actually a company that was wonderful and just without even any, but anyway, so in there, it was late, but that's just to help you feel better about it.
And that was during the conference committee too. I mean, it was that extra time. Senator Gruenhagen gave us time to really sit back, and we collaboratively, Senator Maye Quade was part of that, Senator Abler. We even had the other body that used to, do you remember you used to serve in the House there? Senator
Yeah, I remember
Gruenhagen? So, yeah, even it's all part of that, so, yeah.
So I would like them to respond to that, though. I mean, we did the best we could, evidently, but yet there still was a lot of fraud, and they had to shut down the program, and it actually hurt the people who needed the help. That's my concern, is that the fraudsters ran off with the money, and the ones who actually needed the help are the ones suffering the consequences. So I appreciate if what we're doing here will satisfy the feds and the program, and that there's actually some consequences to people who defraud the state.
So to Senator Gruenhagen, you'd be part of the state plan, I would assume, right? This is how you're doing that, Ms. Crum?
Yeah, Mr. Chair, Senator Gruenhagen. So this is just a first step. This is just looking at how we would redesign a benefit. The actual redesign should include robust program integrity aspects. It could be things like you mentioned, electronic visit verification. That's something in the governor's budget recommendations this year for more services. It could include maybe a more closed provider network. Maybe it's counties want to deliver a service like this when it comes to a case management type health-related social needs model. So there could be a lot of tools that we could implement and we could recommend when we come to you with recommendations. Then it would be up to you, the legislature, to decide, do we need to do more? And certainly we know that we would have to, it's a commitment of ours to bring forward whatever we would potentially bring forward in the future would have to have strong program integrity controls.
Thank you to that point. Glenn, one more, or Senator Gruenhagen, one more follow-up, and then we need to,
Yeah, I
we're
mean,
running out of time.
I'm just going to read a couple quotes from the, Taylor, who came out with the fraud report, the one who was appointed by the
The governor?
Yeah, I mean, I read some of his report. It says, he identified allegations that employees were instructed not to pursue suspicious activity, and that other employee fraud prevention efforts, these are actual quotes right from his report, prevention efforts may have been impeded. Each such instance must be independently investigated to determine what occurred and whether coercive or disciplinary action is warranted, including referral for criminal investigation and prosecution as warranted, the report says. Just one more paragraph. He held a press conference to discuss his review and was asked why he thinks fraud was allowed to spiral out of control. Here's his exact quote, and again, he was appointed by the governor. If a number of people would have taken the steps earlier, the vulnerabilities wouldn't be there today, he said. There will be a need for a cultural shift within the state and the state agencies. So, I mean, this is O'Malley, and again, appointed by the governor. I'm looking at what we got here. I just don't know if it's going to satisfy the feds in terms of releasing that money, or if it's actually going to stop anything, unless people start actually going to jail who's defrauding the state. And I think we need some stronger language. That's my initial thought about this.
Sounds like you need to, I'm gonna get you, you should be part of the conference committee when we send it to its places and come back. So thank you, Senator Gruenhagen. Senator Maye Quade.
Thank you, Mr. Chair, and I promise not to drag this on a lot longer. And Ms. Grom and Ms. Bailey, I know that you've heard me say this a lot, and you're not ultimately answerable for it, but you are in front of us today, and so I need to ask a few questions. So throughout this committee hearing, you've used the phrase, "we decided to terminate." And I strongly disagree with the notion that the executive branch has the ability to cancel programs that the legislature has passed. I sit on both of the education committees. Charter schools in Minnesota, I think, this is one of our Minnesota miracles, but we've had a lot of news stories about charter schools, right? We've had self-dealing and nepotism. Some are owned by for-profit corporations. We spend $1 billion every year on charter schools, and very few of them are actually helping students meet academic standards. By your definition, would you be able to, the executive branch be able to cancel the existence of charter schools because what was happening in them was undesirable?
Up $1 billion, I'd take that $1 billion, wouldn't you? That would help us fund with what we cut last year. So, to that point, Ms. Grom.
Mr. Chair, Senator Maye Quade, I don't think the Department of Human Services has purview over schools.
Senator Maye Quade.
Thank you, Mr. Chair. Ms. Grom, you're correct, but as the enterprise as a whole, the executive branch, the governor, would they have the ability to direct the commissioner of education to end charter schools?
Ms. Grom.
Mr. Chair, Senator Maye Quade, I don't think I could speak to that specifically.
Senator Maye Quade.
Thank you, Mr. Chair. And I think my answer would be no, because the legislature created charter schools.
Correct.
And similarly, we created the Housing Stabilization Services Program. And so, you know, Senator Rasmusson and I we're having a side conversation, and I think that decisive action is important, and I think that being able to act quickly to end a program that we are seeing things that we don't want to have happen in it that are happening is important as well. But the legislature has to be the one to do that. And if I didn't register publicly how very disturbed I am by it happening, because if it happened to a program that I'm like, yeah, that did suck and that shouldn't have happened, where is the line for when it's a program I do like? And I think everything in it should be happening, right? And there really is no line to blur there. Either the legislature creates a program and ends it, or the legislature creates a program and the executive branch can end it, and then I don't know where the end of that is. And so, you know, I'm glad we're putting language forward today, and far be it for me to ever agree with Senator Gruenhagen, but you know, sometimes I wonder, does it matter if we pass laws if the executive branch is going to take over functions of ours? So I just want us to be really clear as we move forward on all programs, like, this is our job as the legislature. I think we should be a full-time legislature, in part because of what we're seeing right now. We have full-time responsibilities. Our neighboring states do, but we have to do that work and can't offload it. At least it can't just be done by the executive branch. If we put into statute that the executive branch could do it, then I would be more than happy to say, okay, you did the right thing. But that just can't be how we move forward for the rest of these programs. And I would love a commitment that that's not the plan for other high-risk programs to be terminated during interim without legislative approval.
Well said.
Oh, I'm looking for a commitment, a verbal commitment from that.
I just want to say that was well said,
Thank you.
Senator.
Everyone loves a
Ms. Grom.
constitutionalist.
Mr. Chair, Senator Maye Quade, I'm not aware of any plan to get rid of programs over the interim. I would say this was an unprecedented action that we did not want to take, and we look forward to more conversations with the legislature to figure out what kind of controls need to be in statute so that we can work together on these issues when they do arise. There are certainly issues where the federal government has a big role in what we do with the Medicaid program, and so we do need to have some flexibility to be able to work with them and the authorities that they have over the program.
Maye Quade, Senator Maye Quade. Senator Abler, to that point.
Well, just an interesting thought. So, I mean, the program is canceled because the feds canceled it. So I think the governor has every right to call the feds up and say, hey, do you mind canceling this program for us? Because they get along pretty well. I think they're just tighter than whatever. Maybe they're not that tight. Hey, Don, can you do me a favor? This program's kind of a mess. You know, could you like get us off the hook here? And anyway, let's have a hot dish together and work out our differences. But so short of that, I think that we would be eligible for all kinds of lawsuits from people that were unduly canceled.
Yes.
Like these well-run operations. Once the feds pull the plug, that's different. So I just wanted to offer that thought.
Yeah, I just find that interesting.
Maybe a
that
ray of hope, Mr. Chair, that conversation can happen with the
There
two
was a
leaders.
certain lawyer that was at the last hearing, Senator Abler, that was in the crowd that has a history of filing lawsuits. And I don't know, you ever heard of the Jensen Settlement Agreement? Yeah, that lawyer was in this room. So the A2 was moved by Utke. All those in favor say aye. Aye. Opposed, same sign. It is passed. Senator Abler, you got the A4. Is that correct?
Mine is it's kind of a separate topic, so maybe it's, do you have other ones on what? I'll
No,
do
just
mine.
the A2 was it. It was 1, 2, there's a 4.
Did we do one already?
We did 1, 1's passed.
Okay.
Utke moved 2,
That's fine.
2 is passed. Now you have the 4. Do you want to?
Yeah, I do. And I have the A4 and I do have a testifier.
Members, do you have the A4? Or it's Ms. Crom and Ms. Bailey, do
Mr.
you
Chair, we have the
A4?
A4, yes.
Okay.
I think they're giddy with excitement about what a cool amendment this is, Mr. Chair. So this is on the same topic. Who has the authority to stop paying people who are innocent? And in the Optum plan, which we're talking about a little later with the redacted report, it was almost built as a redacted program. It was kind of built in secret. People were unaware with the prepayment review program. And then the rollout was not particularly clear to people. They expected that they would be screened with their bills. They were going to send the bills in. They might lose a couple because they didn't qualify.
Yeah.
They had no idea that on New Year's Eve they were going to get zero money. There was no warning. They get their remittance advice on Sunday or Monday. They go to work Monday. What? It says zero, huh? And then they get the money on like Tuesday or Wednesday, which I use to make the payroll on Friday for the average Medicaid provider.
Right.
Lucky Leo would have been fine. He had plenty of money stashed away. But all these bona fide providers live hand to mouth.
Correct.
Anyway, and so, and then just as you, well, that won't, and then there was a delay in some of the other billing because he changed the date by a day. And some people went 4 weeks without.
Yeah. And there was a provider, 30 years in the business, Senator Abler, Duluth, Minnesota, compliant provider, shut her doors, 500 clients because of that issue.
Right,
Not okay.
right.
So does this amendment is?
So this amendment would say, in the forecast, that 2-week shift is now permanentized
Yeah.
by fiat, same topic. And so it's just baked in. There it is. It's a 2-week delay. It's a program. We did not. They had permission to put some kind of program together, but in the programming discussion, there was no discussion about a 2-week delay, which winds up being a 4%. It's 126. It's basically a 4, not exactly 4%. Miss math, but anyway, just right around 4%, 3.9%. Of a one-time cut to people that's a built-in, baked-in shift worth $53 million in the forecast. And that's incredible. And so I don't think they can do that, and this says that they can't. And so, Mr. Chair, I don't know how you want to treat this. I'm going to make it into a bill as well, but if you wanted to stick it on and let it go forward to be part of the dialogue, I would love that.
Then
and
let's do that.
I do have a testifier. Mr. Pollack wants to come down. If you
I don't want to talk. I don't want to let him. He's a former commissioner. We don't let these guys.
Well, come on down. He's come
Former,
over
he
to the
worked
white.
for the other body at one time.
He's onto the light side. He's in the human service world now. So.
For the record, please state your full name.
Mr. Chair, Dan Pollock, and I'm wearing a hat today of representing the Autism Treatment Association of Minnesota. Appreciate the
Welcome to
opportunity.
the committee.
Thank you, Mr.
Pollack.
Chair. I spoke to the association this morning. They worked on this amendment, and appreciate Senator Abler offering it. And this is very similar to what you just talked about with the A2 discussion. I completely agree with what Senator Maye Quade said, and it really is about who has the authority to impose a payment delay, basically with major fiscal impacts. We're pretty surprised to see the calculation in the forecast on page 84 of $53 million of one-time savings. That is an enormous amount of money. That's the kind of money that if a legislator got that on their fiscal note savings, they would be astonished that I have $53 million in savings. And to see it pop up in a forecast page that just falls to the bottom line, that's money that this committee appropriated and wanted to go to these providers. And by the way, we have no problem with fraud enforcement actions and all the payment withholds that are the normal process. So the amendment is drafted to allow the commissioner to do all the work with sanctions and fraud enforcement that are all in current law 256B, .064. That's all in paragraph D. But if providers are legitimate providers doing the work of serving the populations that this committee cares so much about, we shouldn't be we shouldn't be arbitrarily pulling 53 million away from them. That should be a choice for the legislature as part of the budget.
Thank you. We got Senator Rasmussen. Do you want to go, or do you want Ms. Grom? What do you, Senator Rasmussen, do you want to, yeah.
Thank you, Mr. Chair. My question was, I wanted to see if the department has had a chance to review this and if they have comments on this amendment.
Ms. Grom.
Mr. Chair, Senator Rasmussen, we did take a look at it earlier this afternoon when it was posted. I think we have a few questions around, in some ways, how this differs from our current requirements around payment of clean claims for that are within 30 days. And I believe we get 90 days for complex claims. So I think we want to do some work on this, but I mean, we already are required to meet those requirements under law. I would also say this language, the way I'm reading it, and I'm reading it out of context with the whole statute, indicates we must fully repay providers for any claim impacted in a delay. So I guess I'm not clear if the amendment the intent is to require us to pay claims that were invalid or for services billed that were potentially fraudulent or in error. But that would certainly be a concern. And then the language in paragraph C around imposing cyclical ongoing payment delays, I think we would have concerns about that. But I, more importantly, wanted to get to the claim around the forecast impact and ask Ms. Bailey to comment on that.
Ms. Bailey.
Chair Hoffman, members, yeah, just looking at it very briefly, I think actually it would probably have an impact of more than the 53 million one time. We also have some savings in the forecast for denials that we're finding during that prepayment review process. And if we're not allowed to deny claims, that would have an impact on the forecast. We also have some cost avoidance. So one thing on paragraph C where it says we cannot impose cyclical ongoing payment delays, would this just not allow us to do the prepayment cycle altogether? So I'm just, off the top of my head, curious on the financial impacts to the forecast beyond that 53 million.
Thank you. Senator Rasmussen.
Thank you, Mr. Chair. I appreciate the department's comments. I would say, I mean, my sense is that this amendment is a little bit out of place for the bill that's in front of the body, that's talking about housing stabilization services. And I think there'll be other bills, one that was introduced in the Senate today and I believe referred to either this committee or Senator Wiklund's committee, that will be looking at program integrity tools more comprehensively, looking at high risk, medium risk, limited risk providers across services. And I wonder if that is maybe a more appropriate time to have a conversation around some of these trade-offs. Because I also don't want the message of the department's getting here is to, to not have the tools needed to stop tax dollars to go to criminals.
Thank you, Senator Rasmussen. Senator Abler.
Well, thank you, Mr. Chair, and Ms. Bailey and others. This doesn't take away any tools. It takes away an inappropriate action. And so they can still do their prepayment review. This doesn't stop that. They can still hope to get people that aren't going to file a claim that we're scared off. This still allows, this doesn't do anything about a fraudulent claim, the $6 to $7 million that's in the forecast. But it does address the novel addition to the forecast of $53 million that they've never addressed in the past. Even though they have their right to delay 30 days or whatever, it's never been done like that. And so they decided to add it in, and to the detriment of these providers who are trying to stay open. And I wouldn't mind sticking it on to keep working on it, but I think that if this bill is moving, this is a topic. There are companies going out of business because of, I believe, an inappropriate action, even a surprise action by the department on these providers. None of these, when it comes to be found out that none of this $53 million, this is a shift. You already took credit for the fraud part. This is a net shift of a 2-week delay that's coming out of providers who are going to get paid only in a delayed way. So, Mr. Chair, I will listen to your pleasure on this, but I think it's a big deal, and it's really harming these providers.
We're going to go to Senator. Well, thank you for that, Senator Abler. And I like putting everything into and having the conversation. We have lots of space for that conversation all the way up until, and the other body, what we're doing here, the other body didn't do. So we're, so but it's gonna, whatever we do, it's gonna go to Senator Wiklund. So to that point, Senator Wiklund.
Thank you, Mr. Chair. Yeah, I have questions about how would that actually work, and what is C intending to accomplish? So I really think it needs more discussion. I guess I just don't, when I read it, I just wasn't sure what it is attempting to accomplish. Like if a claim is held, but it's paid within the 30 days, I don't understand why that would need to be repaid. If it's something that was held and because it was flagged and they were investigating it and it went beyond 30 days, are you saying that they still have to be repaid for it? I have concerns about what the consequences would be of this language.
Where the float is, Senator Evelyn.
This is, the forecast just came out on Friday. We were unaware of the extent that this is. And we have been aware of the harm to the programs, to no fault of their own. This $53 million has nothing to do with fraud. It has to do with a payment delay.
Correct.
That is the net effect of the payment delay, which we did not authorize. This is now a routine payment delay. Not we have up to 30 days or whatever to pay, but customarily, there's the custom of the department and was not reflected in the forecast of, well, maybe there is some little benefit in the forecast of some delay, but the reason this matters is it crosses the threshold of a year, or a biennium now.
But the fact itself is due to the delay, is what you're saying.
Just to a delay, not anything, not one iteration of fraud. And so, I don't know, Senator Wiklund, if we could try to work on this, I would like that. I think it's a big deal, and I think the providers that are gonna be going out of business or already have, not serving, it's the same as those housing people that were serving housing people. We have people serving home care, we have people giving rides, we have NEMT. We have providers who are living on Medicaid barely, who have been grossly impacted through no fault of their own and through a total surprise. And now the forecast has captured that money as a novel element, meaning they're going to continue doing it even if they don't have to. And this says, if you have to, do it. Every fraud thing in place is there, and it could certainly be improved with the wordsmithing, but I thank Mr. Monahan for working on short notice. So, Mr. Chair, I will listen to your counsel.
Chair Hoffman, can I speak a little bit to why we included it and why it's not an anomaly, actually?
To Senator Wiklund and Senator Abler's point, yeah, absolutely.
Okay. Chair Hoffman, Senator Abler, the forecast reflects payment timing all the time. We forecast based on a cash basis, so it is simply when we're paying the bills. And we already have assumptions on how long it takes us to actually pay a claim. Providers have a whole year to bill, and so there's runoff all the time. And so this $53 million is not so much an anomaly as you might think. It's simply saying for these services that are subject to this prepayment review, we're assuming it's one warrant cycle later that we're paying. I just wanted to mention that this is not unusual. We put timing assumptions all the time in fiscal notes that then get put into the forecast, as well as ongoing programs that we're forecasting on when we actually think we'll pay the bill.
So say that statement again. We put.
The forecast reflects when we're actually paying the bill, not when the provider's providing the service, not when the counties are authorizing the support plans. We're paying when we actually pay claim, or we're forecasting when we actually pay claims. And as such, there's always a natural delay in when a service is provided and when we're paying. And so this is recognizing that we did see a 2-week delay on average that we'll have going forward. But it is no different than all the other timing delays that we have in the forecast.
And to that point, Senator Abler, this conversation of dynamic scoring, why aren't we having that conversation? That point in and of itself, I think it should come, I mean, there's so much conversation in it. Maybe if you want to work on it, I like this, based on that precept that you just said, and it would go to then, which you guys are all, everybody on this committee is on your committee anyway, right? Well, you and Utke and you, Senator Utke and Senator Abler, right? I like this being added to this conversation, because then even going toward Senator Wiklund, when we get together with the other body, that would be a nice conversation, which, guess what? We get stuff done. So I want this. I'm okay with this being put on this bill. So,
Okay, and we'll work on the language a little bit.
yeah. So, I needed to get us going. Sorry, Senator Gruenhagen, unless you got something to add, I'm ready. You got to do one famous quote for me though. So Senator Gruenhagen.
Thank you, Mr. Chair. Yeah, so based on your comments, it seems like this would interfere to a certain degree, this amendment, with deciding who's valid and who's not. Is that correct?
Mr. Chair, Senator Gruenhagen, that's
Ms.
the
Crum.
way I read the amendment, is that this would require us to repay something on clean claims that we're already repaying, I guess, and if there were complex claims that we are allowed to flag and hold for longer to look at appropriate documentation, whether or not there is an error, that this would potentially preclude us from holding those, and we would be required to pay them. So I think
So I,
interferes with our current prepayment.
Go ahead, Senator.
oh, okay. Yeah, so I tend to agree with Senator Wiklund. I think it needs some work before it goes on.
Ooh, we got a split committee. You want to call a roll call too, Glenn?
I think this is the first time I agreed with Senator Wiklund. No, I'm just kidding. No,
Wow.
no, I've agreed other times too. So, especially on prescription drugs. I finally got a laugh out of her though. So I do think that we should wait on this and it should be worked on. We really, think of the two paragraphs I read. We need a cultural shift in the departments. In other words, what are they saying? There's a fraudster shift in there right now, and we need to go to a compliance shift. And if I remember some of the words you said before, we've got the laws in place to actually bring compliance. It's just they're not being implemented. So I hate to do something to further impede your ability to pay the ones who are legitimate versus sorting out the fraudsters. And you people actually cut the checks and stuff. So I hate to throw something in front of you that would make it even more difficult than what it is right now. So I think I have to oppose this and agree with Senator Wiklund, and I will call for a roll call.
Oh, God, Glenn. You don't want a roll call. You don't need a roll call. Why don't you withdraw the roll call? We're good.
We don't do roll calls.
You sure you want a roll call? We don't roll call this committee. That's okay.
I have the ability to call for a roll call.
You could do whatever you want, as long as you say one thing that you're supposed to say, and that's
The
all.
Green New Deal, yeah.
There you go, I got it. There you go. Tumardall, you owe me on that one, so there you go. Cassie. So a roll call was requested, a roll call shall be granted. I don't have our roll call sheets up here. Olivia does have one. The A2 amendment was moved by Utke. Now the A4, members, Glenn, Senator Gruenhagen, you want to vote on the A4 amendment as a roll call? Is that what you want?
Well, whichever one we're discussing right now.
Mr. Chair,
Senator Abler.
I'll just take my closing comments then as the author. This affects fraud nada.
Correct.
This has no impact on fraud. The department has every tool at its disposal to do every fraud thing
Correct.
they ever wanted to do. It merely says you cannot take $53 million out of providers who were counting on the money to keep open to serve people in any of these 13 areas that they were doing a good job at. If they're not doing a good job at it, the department has credible allegation of fraud tools that they can use. They have all the pre-screening stuff. Whatever Optum says is a problem, they can pull all those bills and flag them. And if there's people that aren't going to bill, then they're not going to bill. This has no impact at all on fraud, just so you know, so vote how you want. But I think that the providers who have committed to serve deserve to get paid when they're doing a good job. And that's, I think, that's all. I'll stop, Mr. Chair.
No, you're spot on there, Senator. So Senator Abler moves the A4 amendment. Ms. Willis will call the roll.
Chair Hoffman,
Aye.
Vice Chair Fate,
Aye.
Senator Rasmusson, Senator Abler,
Yes.
Senator Greenhagen,
No.
Senator Maye Quade,
Aye.
Senator Mohammed absent, Senator Uckey, Senator Wiklund. Senator Rasmusson. Sorry.
No, okay. We have 5 ayes and 3 nays. The amendment is passed.
Thank you,
Senator
Mr. Chair and
Abler, thank you very
members.
much.
Thank you. Let's keep working on this. I think it's a big deal. Appreciate it.
It is. Thank you for that point. So A4. Now, I'm going to move the Senate File 3755 as amended be recommended to pass and re-referred to Senator Wiklund's Health and Human Services Committee. All those in favor say aye. Aye. Pose same sign. It passes. Senator Rasmussen, Senate File 3780, it's all yours. Thank you, Department, for being here. That was good. Shake your microphone. Yeah. Senator Rasmusson, did you have council draw up a bill based on the recommendations of the redacted recommendations of the the Optum report there? Tell us about your bill.
Thank you, Mr. Chair. In front of the committee is Senate File 3780. And I'll just set some context for this. I think Minnesotans understand that we have a fraud problem, and our objective on this committee in a bipartisan fashion is to stop the fraud. We want to make sure that with our limited resources that Minnesotans' hard-earned tax dollars is going where it's supposed to go. The Walz administration late last year contracted with a company called Optum to do a program integrity assessment. One of the deliverables of that contract was a vulnerability assessment report. I remember reading about this report in the contract that the state signed with Optum, and I was looking forward to getting the results of that report coming into the legislative session. And unfortunately, Mr. Chair, when I received this report, as did other members of this committee, I was disappointed to find that it's effectively useless to us as policymakers. And for example, Mr. Chair, when I look at the report, and today we had a conversation on housing stabilization services. That was one of the 14 programs that this report reviewed, and they listed out vulnerabilities. But when you turn to vulnerabilities in the report, it's all blacked out, including when you get to housing stabilization services, you can't read a single sentence in terms of what are some of the program integrity vulnerabilities.
And what were the recommendations, then, Senator Rasmussen, to those points? Can you highlight those for us as well?
Thank you, Mr. Chair. I was also anxious to look at the policy recommendations, but when you turn to that section, it's also all redacted. And so you can't read really any of it as policymakers to try to incorporate that into our legislative process.
So, Senator Rasmussen, was this public dollars that were given to this private organization to do this report? Do you know?
Yes, Mr. Chair, the Minnesota taxpayers paid 7 figures for this work to be done, and this report was a part of that contract. And I think the public, too, wants to know what the vulnerabilities, what the policy recommendations are, what are items that we should be looking at this legislative session so that we can take action. And Mr. Chair, some people have seen this report. The governor has seen it. Leadership at the Department of Human Services has access to this report. But I think it's timely that we know and the public know what's in this report so that we can craft policy recommendations to stop the fraud, protect taxpayers, and also protect the programs that Minnesotans rely on, that this committee cares a lot about. And so the bill before the committee would unredact the report, except for proprietary information that Optum has as a part of their trade secrets. And this would allow us to have access to this information that taxpayers paid for so that we can make policy recommendations this session to stop fraud.
Wow. It is my understanding that one of your co-authors on this happens to be Senator John Marty as well. Is that correct?
Yes, Mr. Chair, in both bodies, this has been a very bipartisan effort. I think there are legislators who want to have access to this information so that we can make the best decisions we can.
Members, any questions for the good senator? Senator Aaron Maye Quade.
Thank you, Mr. Chair. And Senator Rasmusson, maybe it's because that report looks like the Epstein files that I'm thinking more like what they do in Congress than here. But I wonder, and I'm not going to try to amend your bill here as it moves forward. I wonder if we might consider at some point maybe even a briefing for legislators if there are pieces in the recommendations that might take us time to implement that would leave programs vulnerable until we implement them and would maybe paint a roadmap. That would be something I'd be open to, but I would really like to see anything in that report, and so that could be an option if that argument's made.
Senator?
Thank you, Mr. Chair, and thank you, Senator Maye Quade. I am open to that option as well. And I would say whatever way we can get access to this information so that we can make the best decisions on behalf of Minnesotans is my goal here. And I think there's a few ways to do this. I think by passing the bill out of the committee today, we show the Department of Human Services and our colleagues that this is something we care about. We want access to this information. And I'm very, very open to making sure that we're not giving vulnerabilities to potential criminals, and happy to work with the department to ensure that we're getting the information we need.
That's good. Senator Maye Quade, anything to add? I just had a moment. Senator Wiklund.
Thank you, Mr. Chair. I too am really would like to get more useful information about what Optum saw and what they recommended. But I have some really strong concerns about just asking them or just telling them that they need to unredact the whole report and make it available to us, because it, in effect, making it available, as your bill says, to the public. I have a strong concern that why would we want to provide access to very detailed vulnerabilities that may exist in our programs today, or may have existed at the point in time that the investigation was done. And I would have strong concerns about releasing all recommendations that they're making on how to address responsibility or vulnerabilities like that. It just doesn't seem like the responsible thing to do with this information. I work on cybersecurity issues in the past few years from an IT perspective. We discuss how to address vulnerabilities related to cybersecurity threats. And when I have discussions in the Legislative Commission on Cybersecurity, it would not be prudent for us to be describing in detail the specifics of how we would go into protecting against any given threat. And so I think this is a similar situation where people are trying to actively create schemes that will defraud the government, similar to a cyber threat, wishes to defraud government or other entities. And I think we need to address that in a way that protects us from ramifications from that. And then I guess the second area of concern is that this report is based on information that they gleaned and analyzed at one point in time with certain information from the department. And I really think it needs to be complemented with an analysis from the Department of Human Services to tell us more about, what their reaction is to some of the analysis that they provided. I mean, it was evident that some of the dollar figures in here are not really supportable by what actually has gotten paid out in claims. And so we need to understand that better. Why have they stated that there could be this savings or this amount of excess spending when it doesn't correspond to actual spending? So I think that if we do want to fully benefit and we do want to take forward recommendations that strengthen program integrity, which we want to do this session, and we want to protect people receiving services and the continuity of care, what we need to do is have an analysis from them along with high-level things that we can glean without compromising information security. So, thank you.
That's, sounds like you're going to have a good discussion in your committee on this, aren't you? Wow. I've been thinking about this moment. I just had a moment. I'm really grateful to be here, sitting in between this, having a conversation, what our committee does really good at. So to Senator Wiklund's comments, Senator Rasmusson, and then I think we're going to Senator Wiklund's committee from here. So there'll be the conversation will continue on. Senator Rasmusson and then Senator Gruenhagen.
Thank you, Mr. Chair, and I appreciate Senator Wiklund's points and concerns, and I would just say that the department has had this report for a number of weeks. The date on the report that I have is January 31st, and I think the deadline set in the contract might have even been in December. So this is not the first time the department's been seeing this, and I would welcome them if they have a rebuttal or commentary that they want to provide to the report, or if they think the report is inaccurate anyway. I think we would all welcome to have that additional information, but it's not a reason to redact a report. And I think even having the conversation with legislators around, are there true vulnerabilities that need to be protected? My hope is that since discovering these vulnerabilities, that action has also been taken to protect against them as well. But it's really tough as legislators who care about program integrity. We get this report and we're unable to evaluate what the vulnerabilities, what the policy recommendations are to go forward. And we just have to trust the Department of Human Services that they're going to get it all figured out in their policy proposals they give us. And I think we, as Senator Maye Quade said earlier, need to assert our independence as a legislative branch to dive into these issues. And if the department wants to meet with me or with you, Mr. Chair, or Senator Wiklund, and talk through things that they think shouldn't be redacted, I welcome that conversation, but that I haven't been able to review the report to date.
To that point, and I think that's what is part of this conversation. I mean, I'm with you on that. I understand where Senator Wiklund's coming from. I don't know the cybersecurity world, so I don't know the vulnerabilities that are being talked about there. But I do know this: I'm giving you taxpayer dollars, and you're giving me recommendations that are nothing but black lines. Really? That's transparency? You and we have to operate in transparency. This committee is operating in transparency, right? And so I think there's a piece there that just absolutely upsets me, you know. And so I'm glad you're bringing this forward, and I'm glad it's going over to Senator Wiklund's committee to have that conversation. And I do want to respect that if there are some cyber whatever that is stuff that needs to be there, but don't just throw a piece of paper with a bunch of black lines on it and go, oh, look at the work we did. So I'm going to go to Senator Gruenhagen, and then I'll be done with my comments. I'm sorry, Senator Rasmusson. So then Senator Utke after Senator Gruenhagen. Senator Utke.
Thank you, Mr. Chair. And to the bill and to Senator Rasmusson and everybody else that's commented on it, I think we need to push this as far as we possibly can, and it's good for the agency too. What have we heard since last summer, last fall? Everything has been fraud. we and the agency need to come forth, and now they see the pictures of this redacted report and go, yeah, it's just more of the same garbage. For the credibility of the operation and spending 7 figures to have this process put in place, we need to show all that we can. And I understand the legal requirements of the confidential materials. That we can still do, but I think we need to take it definitely a giant step forward and show what is being found. What are we doing about the fraud? Because all they hear about is 9 billion here, 18 billion there. They hear the numbers and they're upset. This is one way to show them some satisfaction that we're actually doing something. So I think this is a good move, good step in the right direction. We've got, if it's going to Health and Human Services, if there needs to be something else looked at or massaged before it gets there, but keep it moving forward so that in the end, we've got a product that we can stand behind.
No, to that point, you and Senator Wiklund, it's coming your direction. So you, I imagine there'll be some good conversation. I'm glad we're having this conversation. So, Senator Rasmusson, I think your recommendation is to pass and re-referral to Health and Human Services, correct?
Mr. Chair, I would move that Senate File 3780 be recommended to pass and be re-referred to the Committee on Health and Human Services.
All members say aye. Aye. Opposed, same sign. Thank you for your work. And Senator Wiklund, look forward to that bill going there. We're going to bring up Senator Maye Quade's bill. She's got an amendment, and then I believe Senator Maye Quade, you want to do, yes, lay it on the table. So for further discussion, which is good. Members, Senate File 3617, Senator Maye Quade as an author's A3 amendment. Let's get it to the...
Mr. Chair, the A5 amendment.
Oh, it's the A5. It's a new one. You were working on this. Members got the A5? It's an author's amendment. No, I don't. Nope.
It was passed out at the beginning.
I need some segue music. I wish somebody would. Can you, is there, I mean, can we get some, like, you know, when we're waiting for pages to hand out the, shouldn't we like have some like bumper? Yeah, exactly, right? Thank you. Oh, you were working on this.
Mr. Chair.
Senator Utke.
Mr. Chair, I fully recognize that this is an author's amendment, but it's quite a change. Could we get just a little bit of a heads up? I mean, we're going to discuss it as a bill. You can go either way. I guess we'll get a discussion if we adopt it too. So
yeah, and I believe Senator Maye Quade wants us to have it, and then I believe she wants to just lay it on the table, and then we'll bring it back up at another time. Is that, am I getting that correctly? So
but
yeah, go ahead.
Are we adopting the amendment to it so when we lay it over, it'll be as amended?
Correct. Yes. So okay. Senator Maye Quade to Senator Utke, you guys can have a conversation. I'm going to go take a break.
Senator Utke, you want me to walk you through the amendment?
Sure, go ahead.
Senator Utke.
Oh, I see. You're taking over.
Yeah,
So
yes, yeah.
I was
Senator Utke,
thinking you were jumping in to make a comment. I was going to wait.
Senator Utke, could you restate your question for the bill author?
You know, it is an author's amendment. We can go ahead and adopt it if you'd like it, Mr. Chair, and then we can have the full discussion on what's all in the amendment, because it makes the bill a lot larger. So, but we move according to the
Thank you,
procedure.
Senator Utke. Senator Maye Quade moves the A5 amendment as an author's amendment. All those in favor say aye.
Aye.
All those opposed say no. The A5 is adopted. Senator Maye Quade, to your bill.
Thank you, Mr. Chair. So Senate File 3617, as amended, is a simple but important bill. Currently in statute, we have a definition of chemically dependent person for the purposes of civil commitment. Senate File 3617 first updates that terminology from chemically dependent person to person with substance use disorder. I will note for us members that in 2022, we passed a revisor instruction to change chemical dependency to substance use disorder, but the revisor only changed the noun phrases, chemical dependency, and not any adjective phrases, chemically dependent, so as to not exceed what the revisor looked at as the legislature's intent. And so with intention, we changed chemically dependent person to person with substance use disorder. And then second, the bill deletes an unnecessary second definition of chemically dependent person or person with substance use disorder, so that the criteria for civil commitment aren't different in Minnesota for different Minnesotans. It's just the same for all people. And then last, after receiving technical assistance from DCYF, the bill deletes an unnecessary section of law and changes some cross-references to 253B, excuse me. So that is why it got longer, Senator Uckey, is there were just cross-references to that simple definition that we had to deal with. And that, Mr. Chair, is my bill.
And we have no testifiers signed to testify on the bill. Member discussion. Senator Uckey.
Thank you, Mr. Chair. And Senator Maye Quade, I'm still trying to follow this, and I realize this falls under the civil commitment because I looked it up earlier today. But the fact that we're taking out that language, and then I'm just jumping ahead to what we've got here. I'm just concerned that something's being eliminated. Can you confirm? I mean, to me, it looks like, I mean, if you are pregnant and you have consumed these various drugs, that is serious. It's not only to you, but to a baby. Is that still with the amendment? Am I following that? Are we continuing on with that line of thought? And why wouldn't we want that to be a more serious crime? Because it is. It's beyond just the woman herself. It's bringing the baby along who has no choice in the matter.
Senator Maye Quade.
Thank you, Mr. Chair. So, Senator Uckey, the definition for chemically dependent person, or hopefully to be person with substance use disorder for the purposes of civil commitment, would still be a person who is, I'm looking on line 1.8 of the bill, who is determined as being incapable of self-management or management of personal affairs because of habitual or excessive use of drugs or alcohol or other mind-altering substances. B, whose conduct as a result of that habitual use poses a substantial likelihood of physical harm to themselves or others, and then by, a few different things, or a failure to obtain necessary food, clothing, shelter, medical care. So that would be the definition for every person in Minnesota. We don't need a separate standard for pregnant Minnesotans because pregnant Minnesotans don't change their status or their rights because they're pregnant. They're still people who should be considered the same as everybody else and held to the same laws.
Senator Uckey.
Yeah, Mr. Chair, I'm going to have to work on this a little bit because a pregnant woman is different than any other individual if we're consuming these illegal substances because they do have another person that they're concerned with and responsible for. So I will have to follow up at a later time, but I do have concerns with that. So thank you.
Yeah, I think in this case, we're just gonna keep working on that, but I understand it sounds like there's duplicity of language in there. So maybe clarify that, and then when we go forward. Senator Abler.
Well, thanks. I'm just trying to, I kind of think, I remember when we passed this. Senator Maye Quade, do you remember the history when this came into being, what year?
Senator Maye Quade.
Thank you, Mr. Chair. Senator Abler, I don't actually. I wasn't here. But I can say that it has resulted in some pretty serious criminalization of pregnancy in the state of Minnesota. We rank third after Georgia and Mississippi, maybe. One out of every, I think I have it here as 1 out of every 42 births in the state of Minnesota for over a 6-year period was referred for some sort of investigation because of substance use disorder in pregnancy. And so looking at the civil commitment statute as what's the threshold for which the state gets to hold you against your will, really just saying that the threshold is the same for every person. And I don't remember when it was put into statute, but if you remember, I'd love to hear more about it.
Yeah.
Senator Ayler, it looks like Jennifer Sommerfeld is sitting back there. Do you want to come down?
No.
No. The smartest lawyer in the state of Minnesota could probably answer that question for you.
Well, maybe our staff,
yeah,
Mr.
no,
Monahan, if he would know offhand, if there's I think if you look back in the statutes, you'd find it, but like in the little dates and the history of it. ... See you show up in Human Services, I can spot you a mile away. You can't run away from us. Welcome.
Welcome, thank you, so glad to be here. I will say on behalf of all other lawyers, I am not the smartest attorney in Minnesota. So we just have
So are you
had-
saying the chair has no credibility in making statements from the chair's seat?
Of course not, Chair. Being humble today.
I love it. Welcome, Ms. Sommerfeld.
Yeah, takes this out of treatment. Yes, but he's asking, when did we pass that language into the statute?
Oh, that I don't know.
Oh, right.
Oh, apologies, if you are asking questions about 253B, that is not my statute. I thought you were asking questions about the child protection portion.
I'm sorry, Ms. Sommerfeld, I just saw that, I saw a comment just that you were available to come down and talk on that, but I think Liam Monahan just said it was prior to 1997, so Senator Abler was the only one here.
Oh, I wasn't, Mr. Chair, I did not remember that.
1998.
I was imagining that I remembered.
Glenn was on the school board back then in 1997.
I think it's an implanted memory, Mr. Chair.
Right?
Mr. Chair, I was in 5th grade.
Oh, my God.
Mr. Chair.
Senator Abler.
Well, that's helpful, and I think that if indeed we're arresting pregnant women for using drugs, I think that's probably the wrong direction. There's been a whole lot of efforts about, helping, it does affect some innocent bystander who just had nothing to do with it, and then you got the fetal alcohol kids and all that stuff that we've worked on and the narcodon or whatever, the kids that are affected by drugs. But I think we've moved a long way in trying to not criminalize it as opposed to having them just not do it and find a way that's more productive. I wonder, and this isn't the Judiciary Committee, but I wonder how effective that has been anyway. And if this is getting laid over, right, Mr. Chair?
Mr. Chair, Senator Maye Quade, I think you wanted to lay it on the table, or you wanted to lay it over for possible inclusion?
Mr. Chair, lay it over to make sure we have all the TA we need for this committee before we pass it to another committee.
Oh, because it's gonna, we'll just lay it on the table and then, right, yeah.
So, Mr. Chair, when it comes back up, it would be interesting to me just to have a short summary of what we do now.
Yeah.
Instead of, it seems, some of these, pregnant women are just their lives are very challenged. And I think being arrested is the last thing they need to make it even get anywhere near better. So if this moves them in a way that there's more treatment, we've spent a lot of time on substance use.
Carlton, that was the name of that place. I couldn't think of it. Carlton House. Last year, Senator Utke, do you remember that? The most vulnerable people that was it. It was, yes, anyway, I'm just
Anyway, so
thinking
Mr.
out
Chair,
loud.
so maybe when this comes back up, if somebody from the substance use world can just tell us where we are now and just comfort us that we're not causing harm, I think that's probably where it's going. And this may be an artifact, and I don't know if they're still arresting people for this, but anyway, thank you, Mr. Chair.
No, Senator Maye Quade and then Senator Rasmusson as follow.
Thank you, Mr. Chair, and Senator Abler, you're absolutely right. I can share with you that one of the best times for someone to enter treatment for substance use disorder is during pregnancy. One of the largest deterrents is from knowing that seeking help could get you reported and could get you, civilly committed against your will, losing your children that are already born. And so knowing that seeking help for having substance use disorder while pregnant won't end you up being civilly committed actually increases the odds that people will seek help. And so this is a little bit of an artifact from a different time. And we know that making it easier for people to seek help without punishment is like the best way for people to seek help.
Thank you for that clarification. I get it. Thumbs up. Senator Rasmussen.
Thank you, Mr. Chair, and I'm glad we're going to have another opportunity to take a look at this bill if it comes back. But I guess a couple questions that I have. One would be, and I'm looking at the A5 amendment and some of the language that is removed on page 3, lines 19 and 20. We're taking out, if there are positive test results on a toxicology, that the physician will now no longer be required to report that as neglect under 260E. And then we also on page 3, starting in line 5, are removing language about an emergency admission for a pregnant woman who refuses recommended voluntary services or fails recommended treatment. And then we'll also be removing on page 2, starting in line 5, basically taking out a flag for if there's prenatal exposure to controlled substances. And I guess, Mr. Chair, my overall concern is, will this language and removing this language lead to unborn children being hurt and harmed? We know that controlled substances used during pregnancy can have major negative impacts on an unborn child, and that they can live with for the rest of their life. And I think a lot of these protections that are in state law is to protect the interests of that child and to try to protect them from the controlled the substance abuse that their mother's experiencing. And I think it's important to also note that this is not criminalizing language. This is about civil commitment. This isn't about arresting or sending one to prison. This is about civilly committing someone, which is what we do when an individual's behavior is creating a potential harm to themselves or to someone else. And in this case, it's that unborn child that the state has an interest in protecting through these laws. And so my concern is by removing some of these protections that we're going to be endangering children and their ability to live successful lives.
I get the essence of that argument, Senator Maye Quade.
Thank you, Mr. Chair, and thank you, Senator Rasmusson. I think it's important to really detail what the chapter and lines that you pointed out. So let's start with, we'll start at 2.5. So this definition in here of neglect is actually found in the statute about, it's defined for a statute about duty to report for private or public youth recreation programs. And so essentially what that definition of prenatal exposure to controlled substances is in a definition about youth programs and recreation programs, mandatory reporting. And so I really want to make sure that you're able to hear this. So essentially what we have in law is that a public or an employer or supervisor of a private or public youth recreation program must report to a child welfare agency if the child in their program had prenatal exposure to this list of things, which I don't know how many youth program directors or employees would know that, but also this could be up to, candidly, I have a 3-year-old and she's not in any youth programs. And so I'm trying to imagine the age at which you would encounter a child in order to say, I'm reporting you to a child welfare agency for you or your mom using drugs during pregnancy. Like, it doesn't fit there. But also this definition of neglect was then in other places. And so that's where you're seeing, some of the stricken language. If you go to that 3.6, the local welfare agency can seek an emergency admission for a woman if she's pregnant. That's what we're also actually deleting in the original definition, is that we're not creating a separate standard for admission to civil commitment than already exists in law, or that should exist in law. So they could still, the welfare agency could still take appropriate action, including seeking an emergency admission under the definition of persons with substance use disorder, which is then, going back to the original definition, determined as incapable of self-management, poses substantial likelihood of risk to themselves or others. So that is why that's stricken, because there doesn't need to be a separate threshold for pregnant people. And then, was there a third one you had pointed out? I apologize.
Senator Rasmusson.
Thank you, Mr. Chair. Yeah, page 3, line 19.
Thank you. And then this is a conforming change, 3.19, because we're removing prenatal substance use from a definition of neglect for reporting for youth program employees. this cross-references to that, and so we would delete that as well. This doesn't, and again, I hear your concerns, Senator Rasmusson, that if we remove these, then their children will be harmed, but all of these happen after a person who is pregnant has gone and given birth. Starting on line 3.13, this is a statute about a pregnant person being tested for toxicology while they're giving birth, and then a newborn being tested for toxicology after they've been born. And so none of these prevent people from using substances during pregnancy, but what these laws have the effect of doing is reporting a lot of people to child welfare agencies. Like, again, 1 in, I think, 42 births in Minnesota were referred in some way. And so it's overwhelming the system. It's ensnaring a lot of people, particularly Black and brown women, in a system, and the drug tests aren't even all that accurate. So it's not removing ways for people to get help or removing ability for people to stop using substances when they're pregnant. But what it is doing is making sure we are not creating separate standards for pregnant people than people who are not pregnant, and not submitting them to different standards, especially for civil commitment, than other people. And also removing the fact that youth program employees don't know if somebody used substances during pregnancy.
Senator Rasmussen to that.
Thank you, Mr. Chair, and thank you, Senator Maye Quade, for walking through that. I'll go back to on page 3, starting at line 5, the language that's is talking about a pregnant woman who's refusing recommended voluntary services or fails recommended treatment. You know, that would be before birth. I guess what's the benefit, or why are we removing that language in current law?
Senator Maye Quade.
Thank you, Mr. Chair. Senator Rasmussen, I'll point you to this line right above it, is that the local welfare agency may also take appropriate action under 253B, including seeking an emergency admission under section 253B.051. So that is still available. It's just saying that if somebody who's pregnant doesn't meet the criteria of that, they can't be forced into it just because they chose not to. Like if we can't civilly commit someone who's not pregnant for their conduct, then we can't commit somebody who is pregnant for that conduct. So it's just saying they don't have a special standard for pregnant people.
Senator Rasmussen.
Thank you, Mr. Chair, and thank you, Senator Maye Quade. And I guess here's maybe a little bit of the difference, and I want to hear Senator Maye Quade's thoughts on this. I mean, for me, the reason that this is important, and I think the reason that this was in statute originally, is because when you have a woman who's pregnant, there's a heightened negative impact from substance use disorder, right? It's not only impacting the woman and her health, but it is impacting the health and welfare of her unborn child and their life going forward. And I guess that's why we have a heightened standard. And so don't you think there should be a heightened standard when we're looking at the potential health of an unborn child and wanting to protect that child's development in future?
Senator Maye Quade.
Thank you, Mr. Chair. And Senator Rasmussen, I think the absolute best thing we can do is make sure every single person can get the help that they need and accept or want, unless we have this definition of substance use disorder and someone who can't care for themselves. But I don't want us to create separate standards in law for pregnancy, because that actually sets up a world in which pregnant people get treated differently in law, and that is not what I want at all. I really just would never want to create that standard, and we have that, and it's actually very, very harmful. I think every person who's pregnant, I mean, even if they're in the throes of substance use disorder, wants their child to be healthy and to be born. That's the problem with addiction, is that it's involuntary, right? It is a disease, and the best way we can get people treated for that disease is by getting them help. And in order to get help, you have to want to do it yourself, right? You can't force people to get healthy, and certainly we don't want to civilly commit them against their will using a standard that's different from other people who are civilly committed.
Senator Rasmussen, that's good. All right, Senator Utke and then Senator Abler. Senator Utke.
Thank you, Mr. Chair, and I just was going to make a quick comment. If we do bring this back up at some point, I think book a lot of time, because this is a conversation that needs a lot of a topic needs a lot of conversation, because I have a hospital north of me that delivers a double-digit percentages of the babies, and they deliver a lot of babies, so there's a lot of them born that are born under the influence. Pregnant women need to be held to a higher standard like the current statute is, because they're not only affecting themselves, they're affecting that baby who is now born under the influence and got a ton of huge challenges ahead of them out of no doing of their own. Their mother did this to them. We don't want her to be consuming drugs and doing this anyhow. We want to help them, but taking this away, to me, is totally the wrong approach. I hope when we bring this back up for discussion that we keep those things in mind, because when I hear about the hundreds of babies born under the influence of, in most cases, drugs and alcohol, but born, that little tiny baby born under the influence of these horrible drugs, I mean, look at the horrible starting position we put that little kid in. Yes, their mother did it, but we need to help all we can, not say we're going to eliminate these things and just say it's, I'm not saying it's okay, but we're reducing the importance of it. It's so important that we need to do everything we can to stop it rather than just accept it.
Yeah, I think that, and to the good senator's point, Senator Maye Quade, there looks like there was some duplicity. It was cleaning up some language, which then it's the conversation. I think Jennifer Sommerfeld's probably going to talk with you, because it's like this is why the senator said I'm going to bring this up and then I'm going to lay it on the table to have the conversation still on it. So this is why we exist here. So I appreciate you bringing this, Senator Abler, and then we'll just lay it on the table and then pull up Senator Wiklund. So.
Well, thanks. And not to repeat anything anybody has said, but clearly this is a situation where one person directly affects another person. We don't want even secondhand smoke. If you remember the anti-smoking things, we didn't put anybody in jail for, well, we actually, it might have been some kind of a crime. But what's the best way to accomplish the goal to have women not use drugs who are otherwise really challenged to not use drugs, that despite their best efforts, to make sure that we harm fewer kids, the fewest amount of kids, which would be zero. And is this method working or not? So I'm friendly to the goal, and at the end, what is actually the best way? And I think Senator Hoffman, as we talk to some of the substance use people, like what are we doing now that actually works? Is there a successful county that's been better at another one, and that's been heavier on the law, heavier on protecting, giving mentors to young people? Because at the end of the day, however we do this, that newborn is going to be affected their entire life if we don't do this well. So anyway, appreciate that, Mr. Chair. Thank you.
Thank you for bringing this. This is why we exist, and I appreciate that. So we're just going to lay it on the table, right? Is that correct?
Yeah, can I?
Oh, yeah, you can. I just was like, yeah.
Yeah, no, I appreciate it. And I think it's a really good and important conversation. And I think it can be really hard to look at law and see the words and ignore what they actually do, and it feels scary. But I do really want to reinforce that the best way for any child to have optimal outcomes is for the pregnant person to have access to health care early and often. People are more likely to seek care when they know that they will remain free after doing so. They're more likely to make healthy choices when they have access to those healthcare decisions. And people are more likely to get treatment for substance use disorder when it's brought to them by a trusted provider and not through force. And so I totally agree with you, Senator Abler. We want the most kids to arrive on this planet healthy and safe and loved. And the best way we can do that is give the same dignity and autonomy to their mothers as the rest of us have, and not have their status and their ability to be free out of government custody change based on their pregnancy status or lack thereof.
Did we already pass your A5 amendment?
We
Yeah,
did, Mr. Chair. Yes.
Thank you, Senator Rasmusson, for doing that. With that, we're just going to lay this on the table, and I like the essence of this. Get to work. So thank you for doing this. Senator Wiklund, now Senate File 3733. Once again, sorry, Kathy Messerly. I can't control the dialogue that goes on in this committee, you know, it's just, you know. I blame the good senator from Glencoe, because he asked for a, you asked for a, what's that called? What is that thing?
Roll call.
Something like that, roll call, snowball, something, it's like. Senator Wiklund, welcome to your committee.
Thank you. Thank you, Mr. Chair, and I'm happy to be presenting Senate File 3733. It's a bill that was brought to me, and it relates to access to home care services. Many of us share the goal of increased access to the home care services that allow older Minnesotans and those with disabilities or complex health needs to remain living in their homes with their families. It's a preferred choice for many constituents of ours, and it's a key step in easing the stress on our currently overstressed hospitals and other congregate care facilities. The bill before you today was brought to me by the Minnesota Home Care Association, and it offers two small steps the state can take to strengthen home care services in Minnesota. It does two things. It updates the structure for use of home care fine dollars to align more closely with changes we passed into law last session for assisted living fine dollars, and that allows for more consistency and clarity. And second, it ensures timely filling of vacancies on the Minnesota Department of Health's Home Care and Assisted Living Advisory Council. And Mr. Chair, I do have an author's amendment that refines the language and makes it more the way I would like to start.
And Senator Wiklund, is that the A3?
Yes.
Great. Senator Wiklund moves the A3 amendment as an author's amendment. All those in favor say aye.
Aye.
All those opposed say no. The motion prevails and the amendment is adopted.
Thank you.
Senator Wiklund, any additional comments on your bill before we go to the testifier?
No, I was just going to say I'd like to turn it over to my testifier.
Welcome to the committee. Please introduce yourself for the record and proceed with your testimony.
Thank you. Chair and members of the committee, my name is Kathy Messerly, and I'm the Executive Director for the Minnesota Home Care Association, whose members provide hands-on care to more than 30,000 older Minnesotans and individuals with disabilities in their home. As our bill author stated, this bill contains two very small process improvement steps our state can take to continue to strengthen the state's home care service system. And in light of all you've talked about today, this should actually be quite easy and small. So section 1 and 3 of the bill update the structure for use of home care fine dollars that align with the language that was passed by the legislature last session. That language added clearer procedural and timeline requirements to the process that MDH uses for awarding competitive grant dollars to assisted living providers. This proposal in the bill aims to mirror that language and applies these additional process improvement measures to the process for awarding grants for home care providers. The intent of this proposal is to have greater clarity for all stakeholders on the process used for awarding these grants and to allow MDH to have a more aligned and consistent process for awarding the funds. Section 2 of the bill implements a timeline within which vacancies must be filled on the Minnesota Department of Health's Home Care and Assisted Living Advisory Council. This advisory council has been in existence for some time and is charged with providing advice regarding the MDH's regulation of home care and assisted living providers. State statute outlines 14 roles that must be represented on the council's membership. It is critical that each of these 14 voices are able to contribute to the work of this council. Last year, an extensive delay in the selection of qualified applicants for appointment to vacate council positions led to a gap in voices at the table. The language in this bill lays out a clear and common sense timeline for filling those vacancies. We'd like to thank MDH for working with us on the details of these proposals. In closing, I want to thank the committee for taking time to hear this bill today. As our state works to bring better access to home care services to Minnesotans across the state, we must look at all steps that will help us move in that direction. We believe these small but meaningful process improvements will benefit Minnesotans. I'd also like to note that this bill has been endorsed by the Minnesota Leadership Council on Aging. Thank you for your time, and I'm happy to answer any questions.
Member questions or discussions? Senator Aki.
Thank you, Mr. Chair. And question for you that if you mentioned it previously, I'm sorry I missed it, but how much is currently collected? I mean, what type of money would we be talking about?
Ms. Messerly?
Chair, Senator Aki, there is a pot of money that, and I believe MDH is in the room so they can answer if this is not sufficient. I believe there's $1.5 million sitting there, so it will take some time to work through what's initially there, but going forward, it's going to be much, much smaller. There is very little as far as fines that are collected for home care agencies.
Senator Aki.
Thank you, Mr. Chair. And so this has been, that's a pot of money from a while back. Currently, I mean, on a yearly basis in present time, any guesstimate of what's coming in? I mean, it's hopefully it's a real minimal, but just kind of wondering what money would be there to use for these grants after the initial monies are out.
Thank you, Senator Aki. It looks like we have someone from the agency, from the Minnesota Department of Health here, so we'll just.
And I'm sorry, I
give her a
don't
second.
recall, so Daphne can address it.
Welcome to the committee. Please state your name for the record, and we can also have Senator Aki repeat his question if that'd be helpful.
All right, Mr. Chair, Senators, my name is Daphne Pons. I'm the Assisted Living and Home Care Program Manager at MDH. And Senator Aki, if you want to just repeat your question, then I'll answer it to the best of my ability.
Senator Aki.
Thank you, Mr. Chair, and thank you. Yeah, my question was, you know, it lists the fines and such, and then it talks about the grants that would go out. And I realize there's this pot of funding from before, but on an annual basis, current times over the last few years, what type of money is coming in through these fines to be able to put out through these grants? Do you have kind of a number or total on that?
Yeah, Mr. Chair.
I'm sorry, is it Ms. Mons?
Yes.
Ms. Mons.
Mr. Chair, Senator Ecke, essentially there's been a division since assisted living licensure went into effect that kind of distributes how the fines have been looked at. According to our budget officer, as of January 1st, 2026, when we looked at the monies, so pre-assisted living licensure, there on August 1st, 2021, there was a pot of money. They were all comprehensive home care licensees. So all fine monies at that point in time went into the collective special revenue account. And then since August 1st, 2021, we now distribute them by as licensing orders have fines associated. The ones associated with 144A home care go into that budget stream. And then there is the budget stream now for assisted living. So approximately now there is $1.5 million sitting there for home care. A large amount of those fines were collected prior to August 1st, 2021, as we had a large conversion of those comprehensive home care licensees over to assisted living. And now with assisted living, we have available for the grant program that became effective law on August 1st of this year, approximately $3.3 million, but there's also some additional funds. There is a request for a proposal that was implemented last year that had about $800,000 in it. So there's close to a little over $5 million. I don't have the exact number, but it could get you better numbers from my budget officer if you'd like to see those.
Senator Ecke.
Thank you, Mr. Chair. Appreciate it.
That's what he's looking for.
And
Ms. Pons.
Mr. Chair, if you're, and I realize, Mr. Ecke, you're asking for the annual amount. Right now, my understanding is that annually it's about $123,000 that are coming in specifically for home care. So I apologize, I didn't get to that bit. Thank you.
Thank you.
Senator Abler.
Well, thanks. I signed the bill. I just curious, the Department of Health, is this fine with you all? Or are you happy with the bill and it can sail along and all will be well?
Ms. Pons.
Senator Rasmusson and Senator Abler, we have given technical assistance on the bill. We can certainly implement it. We are neutral, but we certainly can implement the bill.
All right. Well, thanks. And Mr. Chair, anything that can make home care work better, that is really the fundamental core of keeping our system operational. If people are served in their homes in a little way or a big way. They don't have to go anywhere else. And if we ever agree on anything, it's like the more of this, the better. So anyway, thank you for your work at the Department of Health and Ms. Messerly and the whole rest of you all, and just Senator Wiklund for this good bill. Thanks.
Any further member questions or discussion? Okay, seeing none, Senator Wiklund moves that Senate File 3733 as amended be recommended to pass and be re-referred to the Committee on State and Local Government. Senator Wiklund, any closing comments before we vote?
No, Mr. Chair, I don't.
Okay, thank you. Senator Wiklund renews her motion to move Senate File 3733 as amended to be recommended to pass and be re-referred to the Committee on State and Local Government. All those in favor say aye.
Aye.
All those opposed say no. The motion prevails and the bill is on its way to state and local government. Thank you, Senator Wiklund.
Thank you. Do you know why?
Members, nothing else on the agenda. Our next committee hearing will be this Wednesday, March 4th at 3 p.m. Until that time, we're adjourned. Thank you.